Hello, everyone, and welcome to the first panel of the day. I hope that you enjoyed your break. We will be talking today about Mahmoud versus Taylor and United States versus Skrmetti, religious freedom, parental rights, and LGBTQ plus rights in a shifting landscape. I want to thank the law school and especially Jennifer Geller for inviting me to moderate this important and timely panel. I also want to give you just a very, very shameless plug. October 9th, we are hosting a panel, 10 years since Obergefell, where we're going to be talking about what's happened in the 10 years since the decision and what's on the horizon. That will feature Judge McShane, as well as Brandon Wolf from HRC, and myself will be talking about different aspects, and so it'll be a good follow-up to this panel, and we'll publicize that. So, as many of you know, we're convening at an especially scary time in our country's history and an especially ugly time for LGBTQ and particularly transgender rights. In dissecting these court decisions, as we are today, with the intellectual acuity that they deserve, we always want to keep in mind that these decisions have consequences, not only in their capacity to alter and limit opportunities that have existed in the near past, but also in licensing behaviors, harassment, violence against their subjects, and against real people. We're also coming together at a time when the mere act of discussing policies, doctrines, histories that center LGBTQ realities is being outlawed either through executive order, legislation, or university policy. And we are really lucky to be in the state of Oregon and at the Knight Law Center, where these discussions are continuing without hesitation, without constraint, and in full recognition of their importance to a functioning democracy and to the protection of human dignity. So to the university, I thank you for this space. So to that end, I want to introduce our awesome speakers. Jeremiah Chin is professor of law at the University of Washington. If you could just raise your hand when you give your name, sir. Never mind, we can all read. He teaches constitutional law 1 and 2 and race and the law, and his work focuses on the relationship between law and social science through the lens of critical race theory. Jen is the co-author of The School Prison Trust from University of Minnesota Press from 2022, which explores the connection between indigenous boarding schools and the juvenile prison system. And he holds a B.U.S. from the University of Utah and an MS.J.D. and Ph.D. from Arizona State University. So thank you, Jeremiah. Robin Maril is an assistant professor of law at Willamette University, teaching con law, administrative law, and health law. Prior to entering teaching, Professor Maril served as the Associate Legal Director at the Human Rights Campaign. Professor Maril's work at HRC focused on federal laws and policies impacting LGBTQ people, including the administrative preparation and implementation of U.S. versus Windsor and Obergefell versus Hodges with the Obama White House. Her current scholarship explores the intersection of con law and administrative law with a focus on democracy and LGBTQ equality. So welcome, Robin. Jim Oleski is a professor at Lewis and Clark Law School. He joined the faculty after serving as chief of staff of the White House Office of Legislative Affairs during the first 2 years of the Obama administration. Professor Oleski's research focuses on the intersection of religious liberty and other constitutional values, and he was a Fulbright scholar based at Cardiff University's Center for Law and Religion in 2019. His 2015 article, The Evolution of Accommodation, comparing the unequal treatment of religious objections to interracial and same-sex marriages, was quoted by Justice Sotomayor in her dissent in 303 Creative versus Elenis. He holds a BA from Middlebury College and a JD from Georgetown University Law Center. So thank you, all three of you, for coming today. Our program today will function as follows. I will give a very short overview of the two cases, which are again Mahmoud and Skrmetti, and we'll turn it over to our intrepid speakers who will take up various elements of these decisions. Professor Maril will provide some comments on Skrmetti, Professor Oleski will offer insights and analysis of Mahmoud, and Professor Chin will analyze the decisions in concert, focusing on overlap and contradictions. I've crafted some questions, and Jennifer Geller collected some questions ahead of time from our students. And while we won't have time to address audience questions in the midst of the panel, we are happy to chat during the break. So, to move forward, the court issued 2 significant rulings this term on LGBTQ rights, U.S. versus Skrmetti and Mahmoud versus Taylor. The first, Skrmetti, asks whether a 2023 law barring specific gender-affirming medical interventions when used to treat gender dysphoria rested on unconstitutional sex-based classifications. Roberts, when writing the decision, argued that although the same therapies, especially hormone therapies and puberty suppressors, were still available for use by minors experiencing other medical disorders, like precocious puberty, the targeted banning of their use for minors to treat gender dysphoria, which is a designation almost universally associated with transgender patients, did not implicate a sex-based classification. Mahmoud asks whether the Montgomery County School Board in Maryland is required under free exercise to reinstate parental opt-outs for their children to skip story hours that feature LGBTQ affirming books. The school district in 2022 had updated its K-5 language arts offerings to include books that center themes impacting marginalized communities. And among the new offerings were stories featuring same-sex marriage. There was a book called Uncle Bobby's Wedding that received a lot of airtime in the decision, as well as a number of gender-affirming books. The county had initially included an option for parents to opt their children out of the story hour, but over the period of 2 years, a significant number of parents used this option because of the LGBTQ affirming books, and they realized it was just too difficult for the teachers to manage. And in 2023, the county removed that opt-out option. Alito, in writing the opinion, sided with the 3 sets of parents who represented Muslim, Catholic, and Orthodox Christian faiths, who argued that without the opt-outs, the story hours interfered with their capacity to freely exercise their religious values in the raising of their children. Both cases center on children who have been the focus of anti-LGBTQ efforts. Both provide a glimpse into potential court responses to the onslaught of anti-LGBTQ state legislation, which is referred to by some as the slate of hate, which has been in full gear since 2016, but especially pronounced since 2021. And both represent the tip of a potentially damaging iceberg that could reset LGBTQ rights, particularly this coming term, with possible cases on trans athletes, bathroom access, and marriage equality. Professor Maril, I will turn it over to you to begin our discussion.
Great. Thank you so much. I'm really thrilled to be here talking about these cases specifically, and I love how you framed it up around the impact these cases have on individual children and families and communities. As Allison mentioned, Skrmetti is primarily looking at an equal protection challenge to a Tennessee state bill. Specifically, this state bill prohibited access to minors for things like puberty blockers, which are hormone therapy, as well as other gender-affirming care, medical related gender-affirming care. Again, for the most part, most youth that are receiving gender-affirming care do receive either a psychological and mental counseling alongside puberty blockers. The surgeries that are discussed in the case and get a lot of airtime are not necessarily something that the majority, or even it's an extremely, extremely small minority of youth have undertaken. I want to look specifically at the equal protection argument at core at Skrmetti. What the challengers of this Tennessee bill argued was that to ban specifically access to puberty blockers for the treatment of gender dysphoria, gender identity disorder, amounted to unlawful sex discrimination under the Equal Protection Clause. This is primarily based on the idea that it is sex discrimination. If you look at Bostock, for example, Bostock is the 2020 Supreme Court case that held that Title VII prohibits discrimination on the basis of transgender status as sex discrimination. And so attorneys argued that for Tennessee to target specifically transgender youth accessing these treatments, that amounted to unconstitutional sex discrimination under the Equal Protection Clause. The majority disagreed, and the majority upheld the Tennessee law, finding that it was in fact not discriminatory, that it was not a question of sex discrimination. Instead, it was a question of whether individuals who had a diagnosis of gender identity dysphoria could access this treatment. Because as Allison mentioned, other youth with other issues, including precocious puberty, could access puberty blockers. The only class of folks who are banned under the Tennessee law from accessing these services are, in fact, transgender individuals. I think what is important and what I really want to look at is the role of equal protection cases that have built up to this initial argument. Specifically, Roberts spends a lot of time analyzing the distinction between the diagnosis of gender identity disorder and dysphoria and access to medication and sex. And the majority decision really relies on a 1970s decision under called Geduldig, if people are aware of this, that held that it was not sex discrimination for California insurance cover to not cover pregnancy. It had been argued that to the extent that only women could become pregnant, to bar coverage for pregnancy was in fact sex discrimination, sort of one of those, I feel like, SAT questions, if A, then B, then C. No, absolutely not. It is not sex discrimination under Geduldig. You might say that's not the law, and you're right, because Congress went back and fixed it with the Pregnancy Discrimination Act. That is not necessarily reflected in the Skrmetti decision. What is important here, I think, to look at is this idea of what is the role of diagnosis and status and conduct. Specifically, I think it's really interesting to look at other queer and trans equal protection cases, specifically like Bowers v. Hardwick and Lawrence v. Texas. For those not familiar, Bowers v. Hardwick was a 1986 decision which upheld a Georgia state anti-sodomy law as it was being applied to a gay man who had engaged in same-sex sex. It was upheld, and what's important about that Georgia case is that the anti-sodomy law was for both heterosexual sex and homosexual sex. Lawrence v. Texas in 2003 held that a Texas law that prohibited only same-sex sex was in fact a violation of equal protection. And Kennedy engages this idea that to engage in same-sex sex is a defining characteristic of being a gay or bisexual or a lesbian woman. And so to go ahead and prohibit that actually criminalized the entire gay existence. What is important here, and where I think it will be interesting to see where Skrmetti goes, is whether we see similar arguments being made around access to gender-affirming care as defining an individual's status as transgender. That it is actually more than just access for care for a diagnosis, but in fact seems to be very akin to the Lawrence v. Texas analysis around a defining set of conduct, the conduct being accessing gender-affirming care. There will be distinctions made, of course, to the extent that this is based on Geduldig, and it is a question of access to care as opposed to criminality, which is at core with the Lawrence v. Texas and Bowers cases. I think that's an interesting distinction that I'll be interested to see sort of where that goes. But I think it's important now to acknowledge where we stand in the equal protection jurisprudence, and as we are looking forward to how the court is going to, I think, treat transgender individuals and the rights that they are claiming.
Okay, great. We're going to move on to Professor Oleski.
So thank you, and thank you to Jennifer and everybody at U of O for hosting us today. So I'm talking primarily about the Mahmoud case, and I need to provide some background before talking about the case itself. And the background for this case is the Supreme Court's repeated change in position on a core question about the proper interpretation of the Free Exercise Clause of the First Amendment. And that question is whether the Free Exercise Clause provides a right of religious exemptions from laws that are not targeted at religious practice, but which have the effect of burdening a religious practice. So to give you an example of such a law, imagine Oregon decided to become a dry state, and to accomplish that, they passed a law that banned the sale, distribution, possession, or use of alcohol. That law is not targeted at people who use wine as a sacrament, but if the legislature hasn't written in an exemption, it would have the effect of burdening the religious practice of using wine as a sacrament. And so the question arises, does the Free Exercise Clause just protect when the government against government action that targets religious practices, or does it also provide a religious exemption right from those generally applicable laws? The Supreme Court has gone back and forth on this from the late 1800s through the mid-1900s. The court's answer to the question of whether there's a right to religious exemptions from generally applicable laws was no. But then in 1963, they switched direction, and from 1963 through 1989, their answer was yes, there is a right, a presumptive right to religious exemptions. Not an absolute right. The government could justify denying an exemption under strict scrutiny, but there was a presumptive right to religious exemptions, the Supreme Court said, sorry about that, from 1963 through 1989. But then in 1990, the court changed positions again in a case from here in Oregon, many of you will be familiar with, Employment Division versus Smith. The court went back to the no answer. Now, this alone brings a lot of confusion to the area, but on top of the flip-flopping, there was an additional complication. In none of these cases did the court overrule its prior decisions. So those prior decisions are still available to make arguments to get exceptions from whatever the new rule is. As a result, I would submit today the free exercise landscape is incredibly uncertain when it comes to religious exemption rights. For one thing, there's at least 3 members of the court who think the court should overrule Employment Division versus Smith. And there's probably 2 others that are interested in revisiting it, but they don't quite know what to do if they get rid of Employment Division versus Smith. But that overruling hasn't happened. And what's happened in the last 5 years is instead the court has granted religious exemptions by finding carve-outs or exceptions to the Smith rule. And the 2 high-profile examples of that are a case called Tandon versus Newsom involving COVID restrictions in California during the pandemic, and Fulton versus City of Philadelphia, which involved the non-discrimination rule with respect to foster care agencies that were providing services in Philadelphia. So we get to Mahmoud, the case that was decided this past summer, and you can imagine at least 3 different arguments for the plaintiffs in Mahmoud who are saying they have a free exercise right to be exempt and to opt their children out of classes where certain LGBTQ plus inclusive materials are being used. One argument is that the court should overrule Smith and then recognize a right to religious exemptions in general that they could then take advantage of. Another is argue the exemption that was recognized in Tandon versus Newsom, which I'm not going to go into the details because we don't have time and it's very complicated. Or third, argue they fit into the exemption in Fulton versus City of Philadelphia. 3 different arguments. The Supreme Court rules in favor of the plaintiffs, the religious claimants in Mahmoud, but not on any of those 3 grounds. Instead, the court recognizes yet another exception to Smith. And that exception to Smith is based on one of these pre-Smith cases that the Smith court declined to overrule, a case called Wisconsin v. Yoder. Wisconsin v. Yoder involved members of the old order of the Amish who sent their kids to school up until the 8th grade to learn the basics, but then, notwithstanding the compulsory education law in Wisconsin, didn't want to have to send their kids to school after the 8th grade. They should be home learning how to become adults in the Amish community. And the Supreme Court of the United States ruled in favor of the members of the old order of the Amish, saying it might destroy their religion if we required them to continue sending their kids to school rather than going and becoming part of the community after the 8th grade. And what the Supreme Court said in the Mahmoud case is that, yes, Employment Division versus Smith says there's generally no right to religious exemptions, but Yoder is an exception to that general rule. And so if we have a case before us where the burden on religion is of the same character as the burden in Yoder, an exemption has to be granted unless the government can meet strict scrutiny. So that, of course, raises the question, when is a burden of the same character as it was in Yoder? And the standard the court gives us, they give us actually two different standards. They separate with an or, which alone is a little confusing, where an educational requirement or curriculum would substantially interfere with the religious development of the child, or pose a very real threat of undermining the religious beliefs and practices of a parent that a parent wishes to instill in the child. I would suggest neither of these are self-defining standards. The court made no effort to further elaborate on the very real threat standard other than to say it was met in the Mahmoud case. On the substantially interfere standard, they said it would be fact-intensive, and they pointed about a number of factors that might be looked at, one of which is whether the material being presented to children is neutral. And the court ultimately concluded that the materials in Mahmoud were unmistakably normative and celebratory rather than descriptive and neutral. I'm going to come back to that point because it's important as to the impact going forward of the Mahmoud case. But I want to make a couple initial observations. First, this standard the court has given us sounds a lot more to me like what Justice Breyer used to champion when he was on the court than what we are familiar with the conservatives championing. It's a vague standard backed up with a totality of the circumstance multi-factor balancing test. And for decades, the conservatives, including Justice Scalia, argued that's the wrong approach because it leaves it to the subjective preferences of the justices. You got a multi-factor balancing test, you can come out anywhere you want. So that's interesting. Related to that, one thing that's interesting is there is not a word about originalism or history and tradition in the Mahmoud decision. Many of you are probably familiar with the fact that the Supreme Court in recent years, in the Establishment Clause context, in the substantive due process context, in the Second Amendment context, has upended doctrine from the 20th century and said we've got to follow originalism and history and tradition. But here, the court is seizing on a case from the 1970s to say we're going to grant this exemption with not any discussion of whether it can be reconciled with the original meaning of the Free Exercise Clause or the history and tradition around the Free Exercise Clause. As for the impact going forward of Mahmoud, I would suggest it's narrow in one respect, in that it's limited to a particular context, parental rights to direct the religious upbringing of your children. It provides no guidance for free exercise clauses in other contexts, free exercise clause claims in other contexts. But there's a lot of children in the country, a lot of children going to school in the country. And the right that is recognized seems pretty broad. Again, the court concluded the books in this case were unmistakably normative. The court also says that, like many books targeted at young children, these books are unmistakably normative. That means there's probably lots of books on the shelves in the schools that are normative and that parents could object to on religious grounds, and it remains to be seen how broad that impact is going to be going forward. I'll just close. I was not charged with talking about Skrmetti, but I'll just make one observation related to Skrmetti, which I think is much more threatening on the whole to LGBTQ rights than the Mahmoud case. In fact, there's one aspect of Mahmoud which you could say would give a religious parent a right to bring a separate challenge to the type of law in Skrmetti, and a colorable challenge to that law. That is, I have a religious upbringing, I have a religious belief that my child should be who they are, and I want to direct their religious upbringing by enabling them to have the gender-affirming care they need. And I think it'll be interesting to see if claims like that are made going forward and how the courts address them.
Okay, thank you, Professor Chin.
Thank you, and thank you to my co-panelists and everyone for having me here. I'm thrilled to be down at the University of Oregon, and I'm particularly honored that you would invite somebody from the University of Washington down here to talk. What I wanted to focus on is the piece that I think both of my co-panelists really raised that the court really ignored in both cases, and that's the rights of the children. Particularly in Skrmetti, you have parents bringing a claim on behalf of their children receiving gender-affirming care, so it isn't just anti-trans writ large in the opinion, even though that's kind of the impact and the focus. The directed harm is on these children who are seeking to receive gender-affirming care, and oddly enough, the parents who are defying the state to bring the right on their behalf. So whether or not the parents raise a religious claim objection, Skrmetti itself was a parental rights claim against the state to say, we are directing the care of our children, and now the state is interfering with us. Flip that on its head in Mahmoud versus Taylor, where you have the state saying, we want to have all children in a classroom read a story together so they can learn about different experiences, and you have select parents saying, we want our children out of that classroom, removed during story time, and no mention officially from the teachers. And the court says, yes, parents have a right to control the upbringing, to essentially micromanage a school district whenever a storybook being read about that they don't like is being read from. And the court in Mahmoud says there's a constitutional parental right to do so. Absolutely ignored in the fact is that you have children in those classrooms who have a free exercise right of their own, and whether or not they believe the same thing as their parents is never addressed anywhere within the controversy of Mahmoud. Whether or not these children have the same fundamental religious beliefs is a part of a free exercise claim, and honestly should be, but the court doesn't consider that. The court narrows the claim entirely, as Professor Oleski, I think, well summarized, that there is a parental right to control the upbringing of the child. And so that parental authority and control is where most of the court's authority is leaning on in Mahmoud versus Taylor, and the idea that the parent can direct the control and upbringing of the child, so long as it fits within, to use Justice Alito's language, the normative guidelines of what the court imagines is proper or fair, which, as we know from Justice Alito and the many flags that he or his wife flies over their homes, the different standards than some of the parents that in Skrmetti or parents opposed in Mahmoud versus Taylor would have. So the elimination of LGBT school books from the curriculum now no longer has to be done through censorship laws or through actual state action that is challengeable within a court, but instead we have this kind of slithering around our state action doctrine, our traditional civil rights remedies, in order to create this place where any parent can pull their child from any classroom at any time because a teacher said the word gay. And now we have something that is directly contrary to the parental's religious fundamental beliefs, which, to be perfectly honest, have a really good standard, which just says the court's not going to interrogate how deeply you believe something. You just have to make some showing that this is a part of your religion, a part of your faith. They went a lot further in the cases that the court cited to, in cases like Mahmoud versus Taylor, where they're leaning so heavily on Wisconsin versus Yoder. In Yoder, they're actually bringing up experts on the Old Faith Amish religion to testify about how essential this ability to leave public education and join the Amish society entirely is a part of the Amish faith structure, and to prevent children from doing that by requiring them to go to school beyond the age of, I believe it was 14, or was it 16?
It's 8th grade.
8th grade, okay. Well, it depends on how smart you are, I guess, right? But so beyond the 8th grade would now directly contradict not only the Amish faith, but also their entire way of life within their community. So it's part of a group element in that. One piece of Yoder that the court completely ignores, as maybe of no surprise to folks, is the dissent from Justice Douglas in Wisconsin versus Yoder, where he raises the important question of, did anybody ask these kids whether or not they want to be Amish? No one is thinking about whether or not these children, who are the actual subjects of the dispute, who are the actual participants, the believers, the idea havers, the faith participants in any of these settings, are actively engaged with the belief system in this way. So the children aren't making a free exercise claim in Mahmoud, it's their parents. They don't want them in a classroom where they could learn that there are other human beings who have different belief systems, faiths, sexual orientations, identities than them, and that's okay. And that's really what these children's books are talking about. You have a lot of very scary selective quotations and out of context mentions from both the plaintiffs in Mahmoud versus Taylor and the court. I was a contributor to an amicus brief from a bunch of children's rights scholars in Mahmoud versus Taylor, where we actually read through the children's books because of the briefing by the plaintiff that are talking about leather-bound people at a pride festival. They're talking about like a leather briefcase. They're not talking about, there's no leather daddies in these books, so that might be an interesting elementary school curriculum. Right? The court is afraid of just simply the idea of an LGBTQ community and using that as a scare tactic. Meanwhile, to return back to Skrmetti, it's the harm to the child is that the court sinks so much of the weight of its analysis into. They're worried about these theoretical, unreversible harms that can come from taking puberty blockers at a young age, when in fact, gender-affirming care is not a harm, but rather a very elusive goal for many people to seek the kind of mental health and support that they necessarily require. And then the court undermines the mental health aspect of it in the first place by noting the high suicidality rates among trans youth by saying that, well, this is just really holding it over the doctor's head. So every doctor has to give puberty blockers because otherwise these youths might kill themselves, thus consigning an entire generation of trans folks to death, right? There is nothing to undersell how cruel I think Skrmetti is to an entire generation of people. And I think that that's part of why the children's rights aspect of it to me is so important, because children are being weaponized as a political tool in both cases, either as a tool to be used by parents or as a rhetoric to be exploited by the court in Skrmetti in order to say that we're doing this for children's protection, which is defined as whatever we say we want children to be, not who children say they are, not who doctors, therapists, experts, and even their own parents have said they are in these particular cases. And so now we have a Supreme Court that is talking out of both sides of its mouth that parents have the absolute authority to control the way education works, except with regard to whether or not their children receive gender-affirming care, in which case the state gets to intervene on behalf of the children who are seeking the care in the first place. And we're coming in these huge cycles and epicycles where the court is just kind of reaffirming its own power and authority to control both children and adults.
All right, thank you very much. So as I said, I prepared a bunch of questions, but I'm going to go off script because so many things came up for me in your really interesting talks that I want to start specifically with a question on boundaries, right? What are the boundaries in your decisions? So in Mahmoud, for instance, are all school districts now required to proactively offer parental opt-outs when gay books are presented? Is this only for counties that offered it originally and then took it back? What's the boundary? Is it only for LGBTQ books? Is it for is it for the presence of LGBTQ classmates? So what is the boundary around the injury to free exercise that is present in Mahmoud, if there is one, right? And for Skrmetti, so there's an arbitrary boundary, evidently, between the diagnosis of gender dysphoria and the kids that are diagnosed with gender dysphoria and their inability to take these medications, and strangely they're different outcomes that they experience from the exact same meds taken at the exact same time, right? Versus, right, kids that are similarly aged that are going through precocious puberty. So again, what's the boundary, right? Is there a limit to the court's capacity to take seriously what seem to me to be arbitrary, not evidence-based boundaries? And is this distinction between diagnosis and classification something that we can sort of pinpoint to a particular sort of context? So, boundaries.
So starting with the Mahmoud case, I guess it might be helpful to separate out legal boundaries and practical boundaries. Because, in terms of the law, the court's decision in Mahmoud is not limited to LGBTQ material. It relies on the Yoder case. It says if you have a similar burden to Yoder. Yoder was a case about a completely different issue. So the right is one that parents could invoke in a whole host to object to a whole host of different materials. And as the key phrase from the court again is, these books are unmistakably normative, like many children's books, the court says. So it seems to me it could be legally quite broad. And, there are a lot of, this was a case involving a very liberal area of the country with, at least the perception is conservative parents opting out. You could imagine a lot of conservative areas where maybe the school district is making choices about the curriculum, where more liberal parents are seeking to invoke this case to opt out. Now, as a practical matter, whether there is going to be the interest and will in bringing cases outside the LGBTQ context, I'm not sure. And so effectively, and this gets into the weeds a little bit, so I'll try to do it quickly. In the past, we've thought about opt-outs from parts of the curriculum to specific separate portions of those curriculum, like the sex ed curriculum, which, by the way, this school district involved in Mahmoud still, has allowed all along. You can opt your child out of sex ed. But what was going on here was trying to make the general curriculum inclusive of all people. And it wasn't just LGBTQ people. It was different ethnicities and races who weren't reflected previously in the curriculum. Just make the books in the general curriculum more inclusive. And the school district was saying providing opt-outs for that is much, much more difficult. And yet the court said you have to do it. So going forward, effectively what school districts might do is say, we just can't practically do those opt-outs, so we're going to take these materials off the shelf. And so if it's just LGBTQ or opposition to LGBTQ materials that are actually brought, then it's only those materials that will be coming off the shelf. And I think it remains to be seen whether other parents with other religious beliefs bring claims in the future.
Great, thank you.
Well, I want to start with the, okay. I want to start with the actual sentence from the decision, which is, SB 1 does not exclude any individual from medical treatments on the basis of transgender status. Mm-hmm. This isn't a case about being trans. This isn't about trans kids. This is about a medical diagnosis that then will determine what kind of treatment you get. It sure seems to be a lot about trans kids, I think, to their families, and to their communities, and to the doctors that have been treating them. But I think the court does go to very great lengths to really distinguish and say, trans kids have access to puberty blockers for precocious puberty. We are just not giving trans kids access to puberty blockers for gender-related care. And it's interesting because when I was preparing for this today, I ran across a lot of critiques actually from the right that this did not engage this question of quote-unquote transgenderism in the court. That the Roberts Court was too narrowly focused on this diagnosis versus status idea. That it should have engaged the idea of being trans and having those rights in the court. I think that going forward, there is, I think, a push to open the door to that, because I think even it's so clear that it is actually about trans youth, and it's hard to sort of buy this idea that it is just about diagnosis, especially when you look at it through this context of, well, how else have we viewed equal protection in the exercise of sort of like life-defining liberties, especially in the queer context. But I think that with that, it could open the door to sort of a, I guess, resurrection of Scalia's sort of morality ideas. If we really go back into making this about transgender rights, as some on the right would like to do, it opens the door to challenge other decisions, including Lawrence and including Obergefell, which we know that there's appetite on the court to do. So my conclusion is the boundaries are very firm and seem to frustrate everyone on all sides.
Did you want to ask a follow-up question?
I just wanted to add to a point that Robin made both in her opening presentation and now just again about sort of the close identification of gender-affirming care and being trans. And it makes me think of a famous Justice Scalia quote, which is, a tax on yarmulkes is a tax on Jews. And I think you could, insert, a tax on gender-affirming care is a tax on trans people. And the court doesn't, I think, reconcile its past recognition, including in cases involving sexual orientation, where it's invoked that tax on yarmulkes language, with its opinion in Skrmetti.
I think the rigidity of these boundaries, I think, is a really important piece too, because like the boundaries are only as rigid as the court wants them to be. And so I feel like today and by today I mean like in this era of the Supreme Court, everything's obscenity, where it's just we're gonna know it when we see it. Is this a Title VII violation? I don't know. Let me look at this particular case and decide whether I like them or not. And that's, I think, the contrast we get from Mahmoud and Skrmetti, where your parent has your right to control the religious upbringing of your child in Mahmoud, and that requires a heightened scrutiny for school district policy. And so thus the administrative reasoning and burden on a school for not providing an opt-out is higher. Right, the school in the Montgomery County schools in Mahmoud, they were talking about the administrative infeasibility of this standard because they had just no way of recording when, who, and where children were being opted out. They were worried about the stigmatization of youth of here's your separate quiet room where we don't talk about gay stuff, and here's the other room where everybody gets to talk. And so now you have the stigmatization of both those religious children and the parents who don't religiously object, not to mention the children of LGBTQ parents within that school district whose children now might be subjected to additional stigmatization. All of that is ignored because now the school has to make a heightened showing that it decided not to provide an opt-out, right? Versus in Skrmetti, the court lowers the standard for states to inflict this kind of burden on medical decision-making processes by just saying the state has to have a rational basis for implementing this law. And what is the state interest in these cases? Well, the protection of children. How does this protect children? From what exactly? The court in Skrmetti isn't particularly clear, but it seems to be that it's protecting them from being trans, being themselves, or receiving gender-affirming care. Not that gender-affirming care, to Professor Maril's point, is essential to being trans, but that gender-affirming care is a part of that experience for these youth that they are seeking to have the state not stop them from doing. Right? And so the boundary in both of those cases becomes, I don't know, it becomes like the status quo of the power hierarchy. I don't know if that's too, woke a sentiment to provide. Maybe it's the mind virus talking instead of myself. But I think that that's just the point that we're at in Supreme Court administrative jurisprudence, is that this line and boundary setting of generalized rules is shifting back to the particular circumstances and contexts of how these justices, whether they feel it's normative or, to use another Alito phrase that he likes to use, freakish, right, in the eyes of the court. And so I think that's the big weighing mechanism that we wind up with.
Okay, great, thank you. I want to turn to one of the questions that the students raised. So the outcomes of these two cases seem to say opposite things for and about parental rights. How can this be reconciled, especially since Skrmetti involves a question of parental rights in healthcare, which seems to be a situation with far more long-term implications than those raised in Mahmoud? Whoever would like to go first.
Want to start us off?
Sure. Often what I like to say in class is, I don't make the law, I just teach it, okay? So that did not go over as well as I usually, students usually love it. But with that, I can't necessarily make it make sense because sometimes things aren't consistent in application, and I don't mean to be cynical or jaded about the court, because as I was actually just saying before this panel started, I really love the government, and I really love the court. And I think that it owes us so much. But I think in this moment, I struggle to reconcile this. I struggle to see how we can sort of parse it. I think to the extent that I can, Skrmetti, to the extent that it involves medical care, and the state has such a profound interest and a really just well-established interest as a police power to regulate medical care across the board and health care. It's just what we've seen in the abortion context. If abortion is not a constitutional right, you just get equal protection. I mean, you just get rational basis protection, and therefore that's why states can really, really regulate the heck out of it, right? Because your states are almost always going to have a rational basis in making sure that health care and medical decisions are as safe as they want them to be. And if it's a rational basis, it doesn't necessarily have to be founded in science or smarts, right? And I think that it is something that we are all going to have to sort of struggle with, and we can, I'm sure there will be lots of law review articles written over the next 2 years that will be brilliant and will make all sorts of sense out of this, and will do the work of the justices for them as to how this makes sense. And I cannot wait to read them.
So I'm going to offer both a technical and a less technical answer to the question. The technical answer to the question is the court didn't grant cert in Skrmetti on the parental rights claim. And, and it's not just the court. The Biden administration, which filed one of the cert petitions in the case, did not seek cert, if I recall, on the parental rights question. Now, the parents did, and the court could have granted the parents' request to grant cert on the parental rights issue, but the court didn't, and the court only addressed the equal protection claim. So that's a technical answer. The non-technical answer is the parental rights claim in Skrmetti was different than the parental rights claim in Mahmoud, in that the parental rights claim in Skrmetti was a substantive due process right claim. And there's, 2 very old cases that have been on the books for a very long time. But substantive due process is the same theory that supported abortion rights and supported marriage equality rights, and the court seems to be moving away from substantive due process. By contrast, the claim in Yoder was a First Amendment parental right to direct the religious upbringing of your children. I think the court is more open to that. I do think going forward it's going to be interesting to see if parents who are not religious do try to bring substantive due process claims, and if the court explicitly recognizes, yeah, you can opt your child out of classes because of your religious beliefs, but not because of your moral or ethical beliefs that are non-religious. But I think that might be the future.
I think part of my hope for that also comes in from weird places and how some of these cases can be turned against each other. Because to build on a point you made earlier about employment division versus Smith and how the court seems really ripe on overturning that to some degree, part of the weight that Yoder gets in future opinions from the court is because Scalia carves it out in Smith, saying like, hey, we've also created these generally, yes, this rule that everybody has to go to school till 18 is a neutral, generally applicable law, and that fails my test. However, I love Yoder, so let me rescue it by saying that involves a parental right to control the upbringing of your child. And so therefore, this is a different kind of substantive due process, which Scalia also hated, but he liked that version of it, right? And so that is the kind of sense-making that the court loves to do in creating these exceptions and carve-outs. And I think my argument for the making sense of the parental rights and the overlaps and the contradiction is not to, and just to embrace the contradiction of it in and of itself and think about, to me, I think the larger question is what does this say about the power of the courts, and what does this say about the power of state governments and federal governmental power? Because the level of protection that we became accustomed to over the past, 80 years is in the hands of those who do not believe it in the same way that I might believe that those civil rights protections might be implemented. And so how and in what ways do we make these communities and these possibilities real, particularly for the youth who are subject to so many of these claims. And I think that is less about the contradiction of the court and what it's making in terms of the decisions, but in terms of how we can make law responsibly in the future, how we can shape it as, you know, voters and as participants in the civic system, and how, you know, we can potentially change the cases in the future rather than trying to reconcile this kind of, you know, knot that we've tied ourselves into.
Okay, great, thank you. So I'm going to ask sort of two questions that are going to be pitched to different folks who want to focus on different cases. So the first is sort of what's next for free exercise, and are we leaning into an era of a positive right to free exercise, right? A lot of, when we talk about the Constitution, right, a lot of us, especially folks who study civil rights, always think about negative and positive rights, and how, right, the Constitution is a, you know, a liberties granting, a negative rights granting document, and not a positive rights granting document. But are we leaning into an era where free exercise is sort of being articulated in some way or thought of in some way as a positive right? And then in terms of equal protection, what's next for equal protection? And in particular, I'm curious about equal protection around sex classifications, right? I saw an article on SCOTUS blog. I don't know how many of you read SCOTUS blog, but there was an article that said Skrmetti basically concretizes the court's belief and investment in sex-based biological differences, and that now equal protection is going to be used really to hammer home the notion that there are sex-based biological differences that can essentially validate, right, different policies for different sexes. And so I'm just curious generally, like what's next for equal protection in terms of sex-based classifications, but also what's next, generally speaking, for equal protection. So whomever would like to go first, let me go first.
So the positive rights, negative rights question, I think it's very complicated.
Yep.
So, you know, I think the court would say, oh, we're just, you know, recognizing negative rights, and the debate is it a negative right just from laws that are targeted at burdening religion versus also laws that are generally applicable and have the effect of burdening religion, but it's all a negative right. Of course, that fits a little uncomfortably with the unconstitutional conditions doctrine, which says, well, if government denies you benefits based on your exercise of a right, that violates the Constitution. So that feels a little more like a positive right, and I would submit it feels even more like a positive right if we're not talking about government targeting. Like, it's one thing to say you're not going to get welfare benefits if you express your support for the Republican Party or if you practice a particular religion, that sort of targeted burden that the unconstitutional conditions doctrine applies to. But when it comes to religious exemptions, and you know, we have a generally applicable rule that in order to get this benefit you have to do certain things, then saying, well, but you're exempt from that requirement and you can still get the benefit without meeting the requirement because we're carving out religious exemptions, that does start to feel possibly more like a positive right. And the court, since I mentioned 1963 was when the court first started recognizing religious exemption rights, that was a benefits case. That was an unconstitutional condition case. So if the court returns to that, you could view the court having returned to sort of a positive religious exemption right to benefits from the government.
Okay, great.
Well, I'll be brief, but I think that there's reason to, I think, be concerned about the restrictions around equal protection, specifically regarding sex, just across the board, based on decisions and concurrences that we have seen from this court. And this interest in sort of reestablishing equal protection arguments in sort of a very originalist understanding of what people thought the Equal Protection Equal Protection Clause meant in the 1860s. And I think that is, to be frank, I think that is a dangerous road to go down. And I think that it will cut out a lot of people down the road. But I think it is also a direction that this court is abundantly ready to take on and is looking for cases that will be possible. And I think it's something that we really need to wrestle with and as far as folks that depend on civil rights as part of their sort of identity and how we move through the world, it's something that I think we should be concerned with just in general.
Yeah, I think for me the recent term is gonna show whether or not these lines get crossed. I think for the positive rights and religious freedom, I think about the Childs versus Salazar case that's coming up that has to do with the conversion therapy ban. Colorado implemented a ban on conversion therapy that would prohibit talk therapists from attempting to convince the LGBTQ persons who are receiving that talk therapy that they are not gay. And so that is a type of therapy that the state of Colorado prohibited for talk therapists, but now it's being challenged as a violation of a talk therapist's free exercise to share her religious beliefs with persons who are receiving her services. This is big difference from like the 303 Creative, which is not quite crossing that positive rights Rubicon because it's saying, oh no, you're compelling her speech by requiring her to say, I hope you enjoy your marriage, when she really doesn't enjoy their marriage. Right? And so that, I think, will be the definitive line crossing for the court, for me, of whether or not there is a positive rights analysis, or if it's just kind of this, I guess the way the court is doing it now is almost like more of a double negative analysis. You can't not stop me from imposing my beliefs on you, as far as the court is concerned. And so now they are just kind of doing that through a negative rights analysis, but I think it could shift to positive for free exercise. For equal protection, I think I definitely agree and echo many of the same comments. But there's a particular problem in Mahmoud where the court is just kind of, or Justice Alito is kind of freewheeling with a note 4 of Caroline products and saying like, oh, it's about minorities, it's about women, and totally ignoring the political participation element of Caroline products, where the court was very much concerned that there are groups of people who do not have a fair shake in a democratic system, and therefore it is more important for the Constitution to protect them above others. And Justice Alito is kind of flipping that on its head and saying like, well, as a part of a democratic society, there are people who are in certain ways, and they have to be let to be established in their beliefs. They have to be left alone by the system, and we can't force them to do anything. And so the court's, I think, pretty flagrant misinterpretation of its own history, to me, says that the future of equal protection is just going to be kind of reinstantiating the court's own power of determining what equal protection is, rather than providing us any kind of new guidance.
All right, thank you very much. I want to thank Jeremiah Chin, Robin Maril, and Jim Oleski for being here, for your very, very smart words. And again, Jennifer Geller for inviting us all here. Another reminder that we can continue this conversation on October 9th with our wonderful panel on Obergefell. And again, thank you all in the audience for coming.